Welcome to Sakshi TV's special immigration talk show with attorney Dr. Srinivas Kaveti. I am Preeti Mulbagal, your host for the show. And today's guest, as we all know, Dr. Kaveti is a multifaceted, accomplished international attorney who has studied law in India, Australia, England, and United States. And he is catering to the diversified clientele across the globe. So today, Dr. Kaveti is with us to discuss a very important topic, which is solicitation of minors and its punishments. It has become a very increasingly heavy problem for all the minors and the parents across the globe with the improvement in the technology. So let's quickly welcome Dr. Kaveti and discuss with him the important topic. Dr. Kaveti, welcome to our show.
Yeah, thanks for having me.
So, Dr. Kaveti, as we see this issue called solicitation of a minor, what does that actually mean in legal terms?
Okay, first of all, we need to understand who's a minor. Its own laws, every state. So anybody who's below 18 years of age is a minor. That's number one. Number two, what is the meaning of solicitation or enticing? Means solicitation or enticing means you're encouraging or you're instigating or you're motivating a minor girl to have some sexual activity with you. That is called solicitation of minor. I mean, it could be on a phone, it could be on an email, it could be on internet, it could be via Facebook, YouTube, or it could be on Instagram, anything. It could be on the same city or same state, or it could be in another state, or it could be in another city. It is via telephone, or it could be via email or internet. That's called solicitation of minor when you're trying to do it when you have a knowledge that other side who's talking to you or you're conversing with them, you're texting or chatting, even on a WhatsApp, that the person is minor. That's called solicitation of minor.
How does law define a minor? Is it only always under 18 or does it vary in any different circumstances?
Well, under the immigration law, minor means 21 years below. But under the state laws, every state has its own law. I mean, generalized, anywhere below 18 years is called minor. I mean, that's the same thing in the world. Anywhere, any person who's below 18 years of age, they're considered to be minor.
Okay, got it. So, what are the key laws or statutes in place that address solicitation of minors in the US?
One must understand there is a federal law and there is a state law. Why is that the distinction in this country? Because in America you have 50 states, you have 50 different laws. And federal law, which is which is a law, which is same all over the country. See, let's say sometimes, the analogy is in some states, if you want to marry or if you want to have a sexual intercourse with a minor, if you're getting married, there are some states allow you to marry below 18 years of age and with the consent of the parents. And you have an intercourse after getting married, that's not an offense. But some states they say even if it is minor, you cannot have a relationship or marry because that's called statutory rape. So one must be careful in what state they are and what jurisdiction they are and what does the federal statute says. Federal statute says anybody who's below 18 is a minor. So one has to be careful. I mean, when especially students coming from overseas, and if you're seeing, if the students are from India, if they're coming here to America, I mean, in India, people always, flirt with minor girls of high school. They go out for coffee, they go to a restaurant, they go to movie. They also have consensual sex as well. See, I mean, it is not strictly applied there for statutory rape, but when you say the same thing in America, that amounts to statutory rape. That means even if it is consensual, if she has come with you with a consent, a minor girl, you went to a restaurant, you did some, any activity that constitutes statutory rape, that means no defenses, you'll end up in jail. So one has to be careful. One is knowing the age. The second thing is, most of the times people say that, oh, I don't know that she was below 18. Mistake of age is not a defense. Oh, I thought she was more than 18. No, it's not a defense. So mistake of, one must understand a mistake of law and mistake of fact. You cannot say, oh, I don't know, in this country, dating a minor is an offense. That's called mistake of law, no defense. Oh, I thought she looked big. I thought she's more than 18. Mistake of age, no defense. So one must be very, very careful when you're especially coming from another country, in this country, and especially all these Indian students, and especially who are on H-1B guys, even green card holders in this country, have to be very, very careful. Anything to do with minor, it's no.
So ignorance is not a defense at all.
Right. Ignorance is not a defense. Mistake of law is not a defense. Oh, I don't know the law of this country. I thought it is okay because you do it in your country. I thought it is okay. Mistake of law. And oh, I thought she looks bigger. She looks older. Mistake of age. Oh, I thought she looked older. No defense.
Right. So how do federal laws differ from state laws when it comes to punishing this offense?
Well, one must understand, because when the federal law comes is, let's say you're sitting in New York and you're chatting with somebody in New Jersey, which is interstate. When the moment interstate comes, the federal law applies. And if you're doing some chatting with a woman or a small girl or minor within the state or within the county, and the state law comes. So that's a distinction. And one must also understand, if you're charged under the state law or the city law, because if you're an immigrant other than citizen, if you're a permanent resident, if you're a student, if you're an H-1B, or even any non-immigrant worker, if you're on a visitor visa even, the immigration law kicks in and say, hey, because you're charged under the state law, the immigration law says that, okay, because you committed an offense under the moral turpitude offenses, your visa will be cancelled and you could be deported. So that's what the federal law is, immigration law. So it's not only just one state law, it also triggers under the moral turpitude offenses, and even your visa will be at stake. They would put you in detention, immigration detention. They could cancel your student visa. They could revoke your H-1B. They could even revoke your green card. The law says if you're a permanent resident, even if you're a green card, if you're being convicted under the moral turpitude offenses for sexual offenses, they can even strip off your green card, put you in jail, and send you back to your country. So it's a pretty serious thing. One must understand. It is not a subject which you can take it so easily, like the way you have experience back home.
What role does intent play in proving solicitation? Is it enough that someone attempted to solicit a minor even if no physical contact has occurred?
Okay. Intention means for any crime in the world, there should be an intention. That's called mens rea. There should be a mens rea, means you have to have an intention, clear intent. Mens rea means bad mind. And actus reus, that means you should also, not only just intention, you should try to attempt to do something. For example, you're speaking to somebody on internet or Facebook or on social media or even WhatsApp or phone and email. So you spoke to somebody, you've enticed somebody, you solicited somebody, and you had some reasonable belief that the person is minor, and you've encouraged them, or you've enticed them, or you solicited them, and they said, "Oh, can we meet?" Or you even suggested, "Let's meet somewhere for a sexual encounter." That means actus reus. That means not only your mental state of mind, you also try to do conduct, actus reus, which is action, and mental state and actus reus punishable. So intent is one of the criteria. Second thing, in offenses like this, these are called statutory offenses. Your intent doesn't play any role for the prosecution. They could say that your conduct itself is enough, that you had a knowledge, and you suggested you wanted to go out with some minor when you had knowledge, a reasonable belief. And the other thing is, it is not subjective. The law says it is objective. A reasonable mind, if anybody looks at your text messages, your conduct, whether you reciprocated, whether the other side person is a minor or a policeman, anything, they would see a subject to element and not, I mean, they would see an objective element, not a subjective element. It's easy for the prosecution to prove. So one must keep all these things in mind because these are all defenses you try to do, but it's not going to work. You've got to be careful.
So, with the rise of social media and messaging apps, how have solicitation cases evolved?
Well, thing is, one must understand, because there are a lot of police people are also, undercover people are also sitting and pretending that minor girls, or they're pretending like women, and they're trying to, entice or solicit and, encourage people online. So one has to be careful. Sometimes on the phones, we also get some text messages, and they will send some nice pictures. But they're not them, but they are police officers. So if you start conversing with them, and if you try to, you say, okay, they might even text you 10 times, say, "Oh, can we meet?" And then you ask, without asking them their age, without checking up their background, you go and try to meet them. And even there are some prostitutes, they're sitting and doing it, they behave in a police officer cell. Even solicitation of prostitution is also an offense, some states. So one has to be careful. You cannot say, "Oh, I don't know." You understand what I mean? So all those things are important. And these are no defenses. Once you're arrested, they process you, they send you to jail. Once you're fingerprinted, taken a photograph of your bust, and it comes in the criminal record, and you might not get a job, or the job is there, you might lose the job. Student visa might be revoked. H-1B might be revoked. So many things. So, those are the things which one has to be careful.
So that was one good example about the cops posing themselves as minor girls to catch the predators. But apart from that, how do law enforcement agencies track and investigate such online crimes?
Well, the moment you start chatting, they have all the evidences. And once they have an evidence, it's easy for the prosecution to prove you're chatting. And if you're instigating, or if you're soliciting, and if you're encouraging the other party, and you had some reasonable belief that the person is not minor, that person is minor, but you still went ahead and did it. And if you have encouraged them, things like that, that's one thing. Number two, it's easy for the prosecution to prove the case for solicitation of minors. They don't have to prove beyond reasonable doubt of all the elements of a crime, because solicitation of minors itself is a statutory offense. What is the meaning of statutory offense? The law defines, saying that the conduct itself is an offense. It's wrongdoing. So you don't do that with minors or with women. Or it could be even minor boys as well, it's not only just women.
So, what are some of the challenges that prosecutors actually face while proving these cases, especially when such communication occurs online?
The first thing, the prosecution has to prove that you had a knowledge, and then you had an intent, and then you went and did actus reus, your actions, and your text messages, your conduct, and they don't have to prove that this is a first time offense. That's another thing which we have in this country, that if it is a first time offense, at least the prosecution or the judge gives you some leniency. But in such cases, there's no first time offense defense for the for the defendant. And the only defense the defendants have is entrapment. Entrapment is a defense. That means because of the police have instigated me, and but because of the police instigation, I've done this. I didn't have no pre-intent to do this. So there are a few defenses for the defense, and it's easy for the prosecution to prove. As I said, it's a statutory offense. The conduct itself is punishable. So there are not many challenges for the prosecution to prove this offense.
Okay, understood. So, what are the typical punishments for solicitation of a minor, both at the state and federal level?
Well, you're looking about 10 years actually, and it depends upon state to state again. Some states could be a little less, and some states could be a little more. Depends upon the state subject. Every state is different law. Penal laws are different. So I'll not be able to tell on this which state has got, because we're just doing this for an information purpose, for your viewers. So I don't know which state this would be a typical example. But typically,
But approximately, you say it's about 10 years.
10,
I mean, it's that serious.
Yeah, it's 10 years, yeah.
Okay. Are there any mandatory minimum sentences for sex offenders, registration requirements for those convicted?
See, what happens, once you are convicted, sometimes the worst thing is you come under the database in America, and every county will be reported wherever the sexual offenders are there. Let's say if some sex offender moves into a suburb, into a colony, you will be informed that there is a sex offender in your colony who's convicted, and even after serving the sentence, he comes out. There is a database. You go into that database. So many times you might not be able to get jobs. For example, in child support agencies or in schools, when you're handling children, sometimes women, there are some jobs, military jobs or police officer jobs or fire jobs, things like that. There's some jobs you might not get it because you're a sexual offender. So many times when you go for your criminal history background in IT jobs or something, when they take your fingerprint, when they see that you've been convicted of an offense, you might not get a lot of jobs, federal jobs, state jobs, and even IT jobs, or many jobs you'll not be qualified to get a job. So, and many licenses you might not get sometimes. For example, if you want to get a license to sell liquor, or you want to sell, tobacco, or you want to sell some lottery even, there are certain, requirements are there. If you're an offender, if you committed a felony or a misdemeanor, you might not get those licenses of state. So you're basically stuck in life.
How do courts decide the severity of the sentence? What factors influence it?
Okay. For every state, for federal and state, there are sentencing guidelines. That's a separate chapter. And the judges look into that, and even the prosecution and defense will look into that. Sometimes in the closing arguments, defense makes an argument saying that the jury has to be lenient and the judge has to be lenient in sentencing. So these are all called sentencing guidelines. Based on that, there are some discretions are being used by the judge. Depends upon the background of the person, depends upon what industry comes, age, criteria of age, and many factors. And many times our people say that, oh, he was naive. He came from India. He's a student. He doesn't know these things. And if you make that argument, those could not be mitigating factors. There are definitely mitigating factors. For example, if you're a breadwinner of your family, and if you're having some health issues, and if you're in some important jobs, depends upon your employment, depends upon your education. There's so many, and depends upon your social work to the society. If you're a pastor, or if you're a priest, things like that. There are some jobs and there are some positions which these are all mitigating factors. If you're only a breadwinner of the family, you have to feed your wife and children. Those can be considered. And these are all there under the sentencing guidelines. The prosecution has to follow, defense has to follow. And if there's any discretion of the judge, and most of the time, because there's a jury trial, and jury, will deliberate and say, hey, this guy has to be punished for this many years. So sometimes judge makes a leeway because of the sentencing guidelines and mitigating factors. So there are so many factors are there in sentencing a convict.
So that sounded like one of the common defenses that attorneys use, like he's the main breadwinner. But apart from that, would you be able to give us any other common defenses that attorneys would use in a solicitation case?
Well, again, it depends upon case to case.
Okay.
There are no generalized things. There are so many factors. For example, if the defense comes to and proves that the instigation is done by a policeman or a police
Mhm.
officer, and the defendant did not participate into that, or maybe sometimes the language also, he might not be conversant in English. There are certain colloquialism people might not understand, and it depends upon the age of the person, because there are a lot of people who also come to America for pursuing a bachelor's degree, and these are all 18, 19 years young boys, and they could be minors even, or maybe some people have some mental issues, mental disabilities. There are so many things which they can take it in mitigating. So it depends upon many factors. So
Got
there
it.
is no, scale. Depends
Mhm.
upon case to case.
Okay, got it. So can someone be wrongfully accused because of entrapment or misunderstandings online?
Possibility is there, but the burden of proof is on the defendant.
Mhm.
That means you're being accused, or anybody who is a criminal defendant who's being charged or indicted, they have a burden of proof to show that they have been wrongly or maliciously accused. Yes, definitely, yes. There could be a mistake of fact sometimes. Sometimes it could be wrongly impleaded. So many factors, yes, that can be used.
Okay. So before we close, Dr. Kaveti, I have two questions. One is, what preventative steps can the parents, schools, and communities take to protect the minors from online solicitation?
Well, buyer be aware. So when you're trying to don't do things what you do like what you do in India or any other parts of the world, third world countries. So be careful. I mean, when you're doing it, even if you're dating somebody right now or you're seeing somebody or minors, discontinue with them. And when you're meeting people, try and see their, ID, or ask them, their information, do some basic research, and don't jump into the conclusions. Don't do sexual advances online or in WhatsApp or emails or Facebook or social media. Don't do things like that. So buyer be aware, got to be careful. You've come to this country to get educated. You've come to this country for work. You've come for a purpose. Be aware of all of that before
Okay.
getting into that. And if you're seeing somebody who are minor, stop seeing them. So
Okay.
if you're a minor, don't take a defense saying that I'm also 18 years, 19 years, she's 18, 19, things like that. Because there are some cases Even if you're minor, you could be decided not as a juvenile, but you could be decided as a major. So be careful of those things. So yes,
Basically, don't assume, be informed.
yes, that's correct. That's the right word. Don't assume, be informed. That's correct.
Got it. So finally, before we go, Dr. Kaveti, how can victims or their families seek legal help and emotional support if they suspect solicitation has occurred?
Well, I think they should get in touch with the competent criminal defense lawyers in their jurisdictions. And if they're on a non-immigrant visa or even a green card holder, they should get in touch with some competent immigration lawyers in their jurisdiction and, be aware of it, because ignorance of law is not excuse. So get to know the law, do some research, and don't get into those troubles.
Thank you so much, Dr. Kaveti, for being on our show and for sharing your valuable knowledge and insights on this very important topic. So I'm sure the parents and the minors are informed equally right now after this show. You have a great day.
Thank you.